Whether a company, association, body of individuals have fundamental rights which are guaranteed under Part 3 of the Constitution of India, and can it invoke and enforce its fundamental right, was a question that was referred to a 9-judge bench of the Supreme Court of India in the year 1963 in the matter of State Trade Corporation of India Limited versus Commercial Tax Officer. The Supreme Court analyzed the Part 3 of the Constitution, which provided for certain fundamental rights which were applicable to citizens and some of the rights which were applicable to any person being a citizen or a non-citizen of this country. The Supreme Court analyzed that Article 14, which provides for equality of law or equal protection of laws, is applicable to any person. Also, Article 20, which provides for protection against ex post facto laws or against double jeopardy, was applicable to any person. So was Article 21, which provides for protection of life and personal liberty, which was applicable to all persons. Also, Article 22, which provides for protection against arrest and detention in certain cases, is also applicable to persons. Article 27, which provides for freedom of conscience and free profession, practice and propagation of religion, is also guaranteed to all persons. So these are the fundamental rights which are available to any person irrespective of whether they being a citizen of India or not. On the other hand, certain other fundamental rights have been guaranteed by the Constitution only to citizens, and certain disabilities have been imposed upon the state with respect to citizens only, like Article 15, which prohibits the state from discrimination against any citizen on the ground only of religion, race, caste, etc. Similarly, Article 16, which provides for equality of opportunity in matters of public employment, has been guaranteed to all citizens, subject to reservation in favor of backward classes. Also, Article 19, which provides for certain freedoms which are available only to citizens of this country. So the question that was referred to the 9-judge bench of the Supreme Court was whether the State Trade Corporation, a company registered under the Indian Companies Act 1956, was a citizen within the meaning of Article 19 of the Constitution and can ask for the enforcement of fundamental rights guaranteed to citizens under the said article. The majority held that the word citizen cannot be interpreted to include a corporation or a company registered under the Indian Companies Act. However, the Supreme Court held that the General Clauses Act was applicable to interpret the Constitution, and that Act defines persons as including corporations. The General Clauses Act 1897 provides for the definition of person under Section 3, Clause 42, which provides that the person shall include any company or association or body of individuals, whether incorporated or not. The articles of the Constitution, which employ the word person, applies equally to individuals and to corporations. So, relying upon the definition of person as provided under the General Clauses Act, the Supreme Court held that all the articles of the Constitution which employ the word person would apply equally to individual and to corporations and body of individuals. So, therefore, Article 14, which provides for equality before the law, Article 20, 21 and 22, also Article 27, would apply to individuals as well as to corporations and body of individuals. What the Supreme Court held was that the Constitution has not completely overlooked corporations, and some of the fundamental rights are prima facie guaranteed to corporations as well. With respect to Article 19(1)(g), where the Supreme Court held that the company or a corporation cannot invoke and cannot enforce that right. However, members of the corporation who are citizens can enforce the right under Article 19(1)(g), even if corporations may not be able to do so directly. The members who are citizens, by enforcing their personal right, can effectively benefit the corporation. The only person who are not able to do so are non-citizens, whether as individuals or as member of the corporation. So therefore, the Supreme Court held that the protections which are available to corporations are: there can be no discrimination, no taxation without authority of law, no curbs involving freedom of trade, commerce or intercourse, and no compulsory acquisition of property. Supreme Court held that there is sufficient guarantee, and if more is needed, then any member, if citizen, are free to invoke Article 19(1)(g), and there is no doubt that the corporation in most cases will share the benefit. And therefore the Supreme Court said that the apprehension that the corporations are at the mercy of the government was not correct. It was a landmark decision of that time, and because of this judgment, the corporations, associations, or body of individuals can also invoke their fundamental rights and can enforce it before the court of law.